This is estate planning attorney Jason Lindamood, and I'm a lawyer up here in the Woodlands, just north of Houston, whose practice focuses on helping people through the probate process, as well as drafting wills, drafting trust, and also powers of attorney for my clients. I've had way too many clients come to me when a loved one dies without having a will in place, and inevitably, they need help going through probate. So I wanted to make this brief video about a will, as well as 3 other super important documents that, in my opinion, in doing this for a while, every adult in Texas needs to have drafted. And not only drafted, but done with precision based on your own particular set of circumstances. Let me paint a quick picture for you. Here's what happens if our loved one didn't have a will. The state of Texas essentially makes one for them and requires that their property be split up amongst family in certain percentages based on how closely related they are. Now, in some cases, it's no harm, no foul. But in other cases, it can create an absolute mess. It can also make the probate process itself a little more complex since, as you can imagine, we have to determine heirship, who's an heir, and have a court determine exactly who's entitled to our loved one's property since they didn't have a will. Because, wait for it, remember, simply having a precisely drafted will would have specifically indicated what their intent was and what their wishes were in terms of who gets what and things of that nature. Last couple of things real quick. Besides the will, get 3 other documents for me. Get them drafted that I think are extremely important in case we end up in the hospital or we are unable to handle our own financial or medical decisions ourselves, okay? Here are the 3 documents. First, financial power of attorney. This lets a trusted loved one, or anybody else that we trust, step into our shoes to transact on our behalf if, for instance, we're unconscious at the hospital or otherwise, legal term, incapacitated. Second, medical power of attorney. Same thought process. This allows our chosen person to make medical decisions on our behalf if we are unable to make them for ourselves. Makes perfect sense. Something we need to have. More often than not, my clients don't have it, we need it. Lastly, third, a HIPAA authorization. This allows our loved ones to cut through that red tape and have our medical records sent from one medical provider to another so that our current doctor or hospital has a much better idea of how to treat our condition, especially when time is of the essence. So bottom line, find an attorney that you trust, someone who focuses on this type of law and isn't simply cutting and pasting the same language from client to client, and get these documents in place. I don't care who you get them from, as long as they're able to protect you and your family. So it's one less important thing that you have to think about. And more than that, you'll have peace of mind knowing that it's done. So to recap, a will that's unique and tailored to your needs, financial power of attorney, medical power of attorney, and finally that HIPAA authorization to gain access to our medical records. I'm done. That's all I have for you. Feel free to click around our website to find out some more information about estate planning if you so choose. You can get there by going to estateplaninfo.com. That's estateplaninfo.com. Thanks for watching and take care of yourself.